We work with people who are challenging deportation based on their rights to family life and private life, length of residence in the UK, and we work pro bono. Before I go on to talk about the nuts and bolts of the basic deportation procedure, just a bit more about who we are in case you want to contact us for advice and use our resources. As I say, we work on cases, people challenging deportation based on Article 8, right to family life, and EU cases, not asylum cases because they're covered by mainstream legal aid. We do prison outreach work. We do applications for exceptional legal aid funding, and I'll talk about that a bit later on, but that's in order to try and get people the money to be able to instruct a legal aid lawyer to represent them. We have a range of self-help materials on our website, and that covers lots of the work I'm going to talk about here on deportation, which you might find interesting to have a look at. I work on deportation particularly, but the organisation Bail for Immigration Detainees does primarily bail application work, and there's an advice line that people can call on that. Obviously, lots of those clients have underlying deportation cases, so do have a look at the website and our resources. So areas to cover. Deportation is a massive area, and I'm aware I've only got less than an hour, so to allow time for questions. So I'm just going to cover the basics in the slides, but I've got some resources in the slides. You can read further guidance, and there's things to follow up on that if you want it. So a brief overview of the deportation framework, keeping the legal points to a minimum. Bit about how the Home Office deals with Article 8 cases in deportation, bit about legal aid, what you can and can't get, a bit about the paperwork that people get, how to approach that paperwork, some tips on how to deal with that, particularly when people are not represented, and a bit about appeals, and some tips on self-representation. And unfortunately, lots of people, find themselves having to represent themselves due to lack of access to legal aid. So I'm going to see basic procedures, a bit about the legal framework, just in a nutshell. You've got two key pieces of legislation. The Borders Act, the 2007 Borders Act, which covers cases that don't retain EU protection law rights for some EU nationals and family members. But primarily those sentenced to at least 12 months or more in a single sentence. The Home Office must make a deportation order unless certain exceptions apply. A person is defined as a foreign criminal. That's actually defined in legislation. And that particularly important is that law actually states deportation of foreign criminals is in the public interest. So you have that already built into legislation. That's the one, the most common one we're working with. You then have the 71 Immigration Act, very old but still applies. And that's going to apply to non-EA cases who don't meet or to deport criteria, so didn't get 12 months or more. And EU nationals who some EU nationals are still protected by EU law, but that's an increasingly diminishing number. So there are two key pieces of legislation to be aware of. I'm going to just touch on EU, but most of the talk is going to be on third country nationals, particularly, as I said, because many EEA cases of EEA nationals are starting to fall under the auto deport and the immigration rules deportation now. So the level of protection depends on length of residence as a qualified person in the UK. And in a nutshell, if you've done under 5 years, lowest level of protection applies. Deportation has got to be justified on public policy, public security grounds. 5 years or more, you get more protection. The Home Office has got to show serious grounds for deporting you based on public policy, public security. 10 years or more, highest level of protection. Imperative grounds for public security. The only get really serious offending would have to be relevant to lose on that one. And significantly, so the Home Office to make out that deportation is justified under this legislation. But deportation also must be proportionate, taking into account all the personal circumstances on the ground. That's an important point. Even if there's the risk of real risk of to public security, your circumstances in full, length of residence, family situation, links in the country of origin, length of time here must be mental health, etc., must be taken into account. So you have much broader protection if you fall under the regulations than you do if you fall under immigration rules. As I say, if you look at our website, there's some material, self-help materials on that covering this in much more detail. But I just want to touch on that, and then you can look at those resources. Also, a few more resources you might want to look at under the immigration rules and guidance. Chapter 13 deals with immigration rules and deportation, and sets down the exceptions to deportation based on human rights and how the Home Office interprets those. And you've got the guidance on how the Home Office deals with those and their perception of Article 8 rights and how that relates to criminality. It's well worth looking at that guidance, actually, because it's more accessible than the immigration rules, and it gives you a very good idea of what how the Home Office interprets rights and how they balance out the rights of the individual and their human rights against the rights of the public interest in deporting foreign criminals, foreign national offenders. And it's useful if particularly if somebody is having to represent themselves, it's a useful resource to have. So I want to touch on the implications of deportation, and this is critically important, because if someone's facing deportation, it may mean permanent separation from family in the UK, including minor children. And I've given people often to say, can they deport me when I've got a 2 or 3 year old child who's British? Well, the answer is yes, they can, unless you meet the exceptions. So it's really, really serious implications for people. Once removed and once deported, certain presumptions apply in the rules as to how long the order should last. If you're sentenced to at least 12 months but under 4 years, the presumption is it will remain in force for at least 10 years. If 4 years or more sentence, presumption is permanent. So, I mean, I'll talk about revocation briefly later on. So you can apply before that time to apply to revoke, but the test is very high and that presumption is against you. And the deportation doesn't just fall away, you've got to apply to revoke it, to cancel it. And obviously it's a criminal offence to enter the UK and breach a deportation order. So the implications are huge for people. Exceptions of deportation. The Home Office can't deport people if they would breach the Convention on Human Rights. So the Article 8 point, we're going to talk about right to family and private life, or the Refugee Convention or Trafficking Convention. But of course, we know the Illegal Immigration Bill, which I think you're going to have a talk on later on down the line by another presenter, seeks to significantly undermine those protections. I'm not going to go into that because we obviously don't know the final format, and you're going to have a talk on that separately. But I wanted to flag that up in terms of potential situations becoming even more tough in the future. So exceptions, I mentioned exceptions to deportation. So the Secretary of State has got to deport somebody unless exceptions apply. So the exception based on family life and private life. Private life is length of residence in the UK, involves things like work, study, integration in society, and family life is actually quite narrowly defined. But as I say, it's in the public interest to deport foreign criminals in the legislation. And these exceptions based on family and private life only apply for consideration to those sentenced to under 4 years. If you're sentenced to 4 years or more, you've got to show very compelling circumstances over and above the acceptance of deportation. So you've got a really, really high test to meet. 4 years or more, you really have a difficult test to meet. And the burden of proof is on the applicant, the individual, to make out their case it would be in breach of their human rights to deport them. So you can see so far we've got pretty high tests to meet from the outset. Just briefly what the public interest means, because I said it's in legislation in the 2007 Borders Act, it's in the public interest to deport foreign national offenders. So what is public interest? It's a broad concept. It includes risk of reoffending, but also public revulsion to offending and deterrence. So often people say, well, we have clients who say, well, how can it be in the public interest to deport me when I have, completed all the rehabilitation courses, I've worked for probation, I'm low risk reoffending? How can there still be public interest in deporting me? When it's because it's a broader concept than just risk of reoffending. as just, I mean, there's a whole debate around definition of public interest, but certainly from BID's point of view, that's a very narrow definition, and there's lots of issues around the being in public interest, not to remove a joint primary carer of a child, and that's in the broader interest for the child to be brought up by both those parents if they're both actively engaged in the child's life. But that's a whole nother debate. So the exceptions based on private life, elected residence. This is a really tough test to meet because people often, clients will often say, well, I came as a 2-year-old, for instance, so I've been here, my whole family's here, I went to school here, surely my private life means I've been here all the time, and they can't deport me. But the actual test to meet is actually very, very rigid and quite tough to meet. And you have to meet all 3 tests to meet the exception to deportation, being the public interest based on private life. So you've got to live lawfully in the UK for most of your life, and we have a problem. Often people haven't been lawfully all that time. It may be that for their parent or carer didn't apply to regularize their stay for whatever reason. So many will fall down on that. But even if they meet that test, they've also got to show they're socially and culturally integrated in the UK, and even if they meet that test, there are very significant obstacles to reintegration in the home country. So you can see it's a really high test to meet, and any kind of challenge has to address all of those points. Most people, even if they meet the first test, fall down on the second test, is socially and culturally integrated. And often we found that the Home Office decision letters are actually contrary to their own guidance, because what they'll often say is, well, you've committed offences, therefore you've rejected UK values, therefore you're not socially and culturally integrated. And I've seen that in numerous decision letters. But their own guidance actually states that the offending alone doesn't necessarily automatically mean you're not socially and culturally integrated, and every case has to be considered on its own merits. I just quoted here from legislation. So criminal from the guidance, criminal offending alone does not necessarily mean a person is not socially and culturally integrated in the UK. Whether criminal offending can be interpreted to mean an offender is not socially and culturally integrated needs to be made on a case-by-case basis, emphasis case-by-case basis, and that's what we do often see. You get very cursory assessments for saying, well, offending, therefore you fall down. So if the person has been resident in the UK from a very early age, it's unlikely that offending alone would mean a person is not socially and culturally integrated. So it's really important that we draw attention to their own guidance in terms of whether the assessments by the Home Office are actually adequate. I just want to flag up a quote here from CI Nigeria. It's an important case which also talked about integration, and the key issue here is the level of familiarity with its customs and traditions and beliefs, etc. So I won't read that because I'm going to read. I'll leave you to read that because I know that I've got lots of slides, but just to that shows you a court interpretation of, which is very useful, of what it means to be social and culturally integrated, and it's a very broad ranging assessment. The second, even if you can show social and culturally integrated, you've got to show that there are very significant obstacles to integration in the home country. And note the wording is very significant. It's not just it'd be difficult or uncomfortable, it's very significant obstacles. I want to give some common examples of what the Home Office often consider in the letters as not significant obstacles. This is, I think most of these I've taken from cases where the person came to the UK as a minor, they've been here since age 2 or 3, whole families here, haven't been back to the country of origin. So you'll be fine going back, there aren't problems because both your parents must have transmitted some cultural values to you, so you must have some understanding they'll be fine. Or this is a common one, you went to school there up to the age of whichever it was, 10 or 11, therefore you know about the culture, which seems extraordinary to me that they can think that I have a child who was brought up in the UK and would have a recognition of understanding of the culture in their home country they left from the age of 9 or 10, just they had some time there growing up. You can learn the language, and you've not proved you're estranged. This is a common one. You've not shown you're estranged from family in the home country. So even the person hasn't been there, they said, I haven't got any family links, so nobody I can rely on. They say, well, you're not estranged, you haven't proved you're estranged. So it's a really hard test to meet. But some of the assumptions of the Home Office about, you know, how someone would cope on return, I think are open to challenge. And I go back to what I mentioned in the other case, the Nigeria, that quote, which talks about the issues are, you know, whether you're enough of an insider to understand how things would actually work in that country, to actually be able to integrate and establish a reasonable private life in a reasonable amount of time. But you know, so you really have to set these things out when you're making the challenge, because it won't be properly assessed, we found, by the Home Office, unless you really set it out what the problem is going to be. And this was an example I wanted to share with you from a case we had. The client arrived in 2002, age 14, is now an adult, hasn't been back, partner, children in the UK. Home Office decision letter said you'll be fine going back because it's considered you have retained a knowledge of life in the home country, given that you're a French speaker, which is the national language. In addition, it's considered that you would be familiar with the customs and cultures of the home country due to the fact that you spent the first 14 years of your life there, and you've been raised by your mother from the home country. For most of the time, we've been resident in the UK. So the assumption is that, well, you've got enough of the insider knowledge as to how things work because you were there the first 14 years of your life, and your mum must have told you something about it. So it's quite extraordinary, the position taken by the Home Office sometimes. So you really have to set down what the obstacle is going to be, and make sure you back that as much as you can. Again, another quote from Kamara, which is a really useful case, and the idea of it's useful guidance as to what would be significant obstacles to integration. So I just read this paragraph here. The idea of integration calls for a broad evaluative judgment to be made as to whether the individual will be enough of an insider in terms of understanding how life in society in that other country is carried on, and a capacity to participate in it, so as to have a reasonable opportunity to be accepted there, to be able to operate on a day-to-day basis in that society, to build up within a reasonable time a variety of human relationships to give substance to the individual's private or family life. And that's really useful, because being enough of that, enough of an insider is a really important point, because just being brought up by your mum, who taught you some cultural values from the country she remembered it, and you lived there when you were age 2 or 3, clearly that's arguably not going to be enough of an insider to really be able to establish a private life. So you could argue significant obstacles, very significant obstacles. But that's a useful case to useful guidance, and it's really useful to quote. So exceptions based on family life. This is really quite narrowly defined. So we've got family life with a child, a qualifying child, or a qualifying partner. So I'll focus on the child primarily, because that's really the one that you're going to be looking at and arguing most cases. Qualifying child. So this is called the unduly harsh test on the qualifying child. So it has to be a genuine and subsisting parental relationship with the child at the age of 18, who's in the UK and is British, or has lived in the UK continuously for at least 7 years preceding the de-immigration decision. So, and immediately it's got to be a qualifying child in terms of fitting into one or two of those categories. And in either case, it would be unduly harsh for the child to live in the country to which the person is to be deported. That's known as the GO test. And it would be unduly harsh for the child to remain in the UK without the person who is to be deported, which is the stay test. And I'll talk about those in a bit more detail. But the Home Office definition of unduly harsh is excessively cruel. So it's okay to be cruel, but not to be excessively cruel. So qualifying partner. Again, the partner has to be, it's not just any partner, it has to be a qualifying partner. It has to be a genuine and subsisting relationship with a partner who's in the UK and is British or settled, and the relationship was formed at a time the person or deportee was in the UK lawfully, and the immigration status was not precarious. And again, the unduly harsh test. It would be unduly harsh for the partner to live in the country to which the person is to be deported. because of compelling circumstances over and above those described in paragraph EX2 Appendix FN. Basically what that's saying is it's a really high test. You have to be very significant difficulties to establishing the family life in that country to have any chance of succeeding. So that's a very high test. And really, when we have cases where there's partner children, our focus is primarily on the best interest of children and the unduly harsh test on the children, because it's really hard to succeed on the qualifying partner rule. The best interest of children, again, another reason we focus on the children is that the Home Office and the courts have a legal duty to treat the best interest of the child as a primary consideration, all immigration decisions. And note it's a primary consideration, not the primary consideration. So it can be outweighed by other factors, but it is very weighty. And there's been some very useful case law recently in guiding us as to how we should approach the best interest assessment. So HA Iraq Supreme Court case, really useful. And I'll just flag up some of the key points of that case. So requirement for a full and thorough best interest assessment to be conducted by a decision maker. And that's really useful because often we find in decisions by the courts and by the Home Office particularly, it's a very cursory assessment of the child's best interest. They say we've considered Section 255 of the Borders and Citizenship Act, the legal duty to treat the best interest of the child's as a best interest, the child's a primary consideration. And we think that the test is that it's the best interest is probably for the child to be brought up by both parents, but it's outweighed by your other factors like your offending, and that's very cursory. They don't consider all the full assessment, detailed assessment of what the best interests are, identify them, and then look at whether or not the other factors do outweigh them. It's not a thorough assessment. If they don't carry a thorough assessment, you know, you've got this law saying, this case law saying, well, actually you need to do that, and if you don't, you're wrong in law. That's really important. Recognises the importance of emotional damage to a child, not just physical damage. Again, really important, because what we often have in decision letters is, well, the child, there's no evidence the child would suffer any physical harm if the child were to remain with the other parent in the UK. But there's no assessment or apart from that, or maybe a cursory assessment, oh, the child might be upset if you were to be deported, but basically they'd be fine. It really didn't give a due weight to the emotional damage to a child of losing a parent, and that's extremely important and what we focus on very heavily when we're looking at our arguments, because it's hugely important to have to document, you know, how that child will be affected, because it can be very long-term damage and affect their life, you know, their life chances growing up and their education. So it's a really important factor. Another point here is really important. There's no baseline comparative how a hypothetical child would be affected by separation from a parent. And the reason this is important is because what the Home Office and the courts would often say before this was, well, you know, the child will be upset, but any child would be upset by loss of a parent. That's just the effect of deportation. That's the way it is. This kind of notional comparative of how any child would be affected. And what the courts have said is, well, no, you can't look at how any child will be affected. We have to look at each child in the particular case we're looking at. What are their best interests? How are they be affected? How would you weigh that up? So it's really case sensitive, case specific, and this is really important in recognition of that. The parental offending is not relevant to assessing the best interest of the child. And if you're looking at the go factor, the go test, should the child you know, and the family relocate to the country of proposed deportation, one important factor which is recognised as well, if the child is British, you know, there are lots of benefits in relation to being British and being in the UK as a British citizen, and how you know, moving abroad is going to be, you mean you're going to lose lots of benefits of that citizenship. Not necessarily lose the citizenship, but lose some of the benefits of living in the country where you're the active citizen there. So there's some really important points, and I think it's important to be aware of important helpful case law, because it can be really useful as guides to hang your arguments on, and you know, they're points which the Home Office and courts really have to take seriously. Again, this is another case which very recently came out, again flagging up the importance of the informed, evaluative assessment of the best interest of the child and how the child will be affected, and we're looking at the unduly harsh test. Again, so that's really important to quote. It has to be, you know, the home office have to consider the individual circumstances, and, you know, if you're arguing the case, you want to really focus on the evidence about that particular child. So useful cases. I mentioned previously the very compelling circumstances test. If someone has been sentenced to 4 years or more, their case doesn't fall to be considered under the exceptions of deportation, being in the public interest based on the private life, length of residence, or family life with the parent or the partner of the child. They have to show very compelling circumstances over and above the exception of deportation. And this test has been subject to lots of consideration by the courts, what does it actually mean. And the HA gave some guidance as to all the factors to be considered. And the reason I've put this here, which I won't go through it, you know, all of it before you can read it yourselves on the slides, which you'll get, is it's a high test, but lots of factors to be taken into account in that test. And Home Office often, in their letters of deportation, they often say, well, we don't think we've considered your case. We don't think they're very compelling circumstances, and that's it. They don't really look at all the factors that should be considered when you look at the circumstances. This is very useful guidance, and it's these kinds of obvious things, really. So, you know, length of residence, family life here, family life, what's available in the country of deportation, closed deportation, nature of offending, rehabilitation, period since last offending, all these factors. But it's important to be aware that all things have to be addressed by the Home Office, and equally, if you're arguing the case and you help people, you know, if people are preparing their cases and doing it themselves, it's helpful if they can address each of those points in here with the evidence, if it's a case they have to argue on very compelling circumstances test. Yes, this is an example of where we had a case where we actually won on the very competitive circumstances test. They're very hard to win. We haven't had many that we've succeeded on because it's just so hard to succeed. But he arrived in the UK as a minor, hadn't left since arrival. He'd lost his deportation case a number of years ago, but hadn't been removed. And so now he was a joint primary carer of 3 minor children, 2 of whom were on the autistic learning spectrum. His partner also had a traumatic past, and so the partner relied on him quite heavily for emotional and practical support as well. He himself has some poor mental health issues. I say, when he came to us, he'd already had a deportation order in force, so we had to make an application to revoke or cancel deportation order based on a fresh human rights application. That was based on the length of residence and also the family life. And we were arguing the unduly harsh test for the children. We needed obviously we had to go beyond the unduly harsh test because we had to go beyond the exceptions, but that was one of the arguments, the impact on the children. But we needed a great deal of expert evidence. We had an independent social work report, and I'll talk a bit about expert evidence a bit later on. But these independent social workers are social workers who are no longer, they're not working connected to a local authority, independent. We can instruct to interview the parents, observe the children, maybe talk to the children if applicable, and write a report on the best interest of the children, how those best interests will be affected by if the parent were deported. And that can be useful for helping the Home Office and the court to make those best interest assessment decisions based on best interest, and help them with weighing up the proportionality arguments about deportation. We also had a risk of reoffending report, because although his offending last offending was many years ago, the length of sentence was quite long, and therefore we had to show demonstrate he was a low risk of reoffending as part of the public interest test. Home Office rejected the application, and basically in terms of the approach they took to the children was, well, we appreciate the children be upset, but you can have family life remotely. They often say that. Obviously we would argue that doesn't properly take into account the impact on the child losing a parent and the emotional bond between parent and child, but particularly if there are learning difficulties or autism difficulties, that relates to how that child is going to be able to engage with modern means of communication. So it was a really cursory assessment, and we appealed to the tribunal, and we succeeded. The judge found The very compelling circumstances test was met. It looked at the period of lawful residence, difficulties of reintegration, looked at the impact on the partner, and the impact on the children, and particularly how far they could actually have a relationship remotely with the parent, and found that weighing all those factors in the round, the very compelling circumstances test was met, and he got his 30 months leave to remain, which obviously could be renewed prior to expiring if the situation with family life remains. So, but it's hard to meet that test. You do really have to have your expert evidence to have a real possible succeeding on that kind of test. So expert evidence, as I mentioned, this is really important because the burden of proof is on the applicant to make out that they meet those tests, and that the balance, proportionality balance, should be in their favour of staying in the UK, not being deported. But these things are really expensive. So independent social worker reports, the average cost is 1,500. Of course, depends on how many children and whether there are any kind of health issues or difficulties or mental health issues or learning spectrum difficulties, which are going to push the price up. But that's the average cost. Independent risk of reoffending report, forensic psychiatrist or forensic psychologist, a minimum refund of £2,000 or so. Often mental health reports are important. That's going to be a diagnosis, care and treatment needs, impact on health of return to country of origin, impact on them, that in terms of deterioration of mental health, they're separated from their family support network, impact if they're unable to access necessary treatment. So that's quite a broad range of issues to look at, and the average cost is about £2,000 for that as well, again depending on who's instructed, and how much work is involved in writing a report. But I'm giving kind of baseline figures here really. You may also need a country expert report to look at country conditions, impact on this given the specific circumstance of the applicant, if they've got complex health needs, needing specialist care, would it be accessible, etc. So another £2,000 or so. So you're looking at quite these can be very expensive, and but you do need expert evidence really, particularly if there are children involved. As a minimum, we would have an independent social work report. But that's really important. And another one is the risk of offending, again, is really important, because the burden of proof is on the applicant, and you really want to make sure that evidence is before the decision maker to make an informed decision. And if they don't make an informed decision and weigh things around properly, you've got a stronger case for your appeal. Which brings me on to the next point of, well, how do you pay for these things? Can you get a lawyer? The problem you have is that challenges to deportation based on Article 8, residence family life, are not in scope for mainstream legal aid, which means you, in order to get legal aid, you have to make an exceptional funding application, and you have to be able to show that in the particular facts of this case, if a person doesn't have access to a lawyer to represent them, they won't have a fair chance to make out their case against deportation. They'll be denied access to justice. So these applications are really, really important, because not only to get the lawyer to make the legal arguments, I explained the kind of the difficulties of meeting those tests. So to guide somebody in terms of understanding what tests apply and what evidence has to be marshalled to have any prospect of meeting them, but also paying for the evidence, the expert evidence. So as I said at BID, we do make applications to exceptional legal aid funding, and luckily we have a good success rate. But the problem we have is, as many people, individuals, don't know that exceptional funding is a possibility, and even if when we tell them and we try and support them through it, they can make an application themselves. Most people can't do it because the forms are quite complicated, and people just think they need a lawyer to do it. The problem you have also is many lawyers we found don't apply for it, and that's because the lawyer won't get paid for the work they do on applying for it unless the funding is granted. And it can be quite a lot of work to make the application if you really because you've got to set down, make sure they meet the means test, financial means test. You've got to sit down the merits of the case, why legal aid is merited, what's needed in this particular circumstances. So it can be quite a lot of work. So they don't often make them. So you do have a problem that many people don't simply go into court and not in terms of challenging deportation decision, going to appeals, and they're not represented. So they're not going to know the arguments, they don't know what they've got to prepare, they're not going to know, they're not going to have the expert evidence. So it's a real problem. What we've also found is that even when we've managed to get the funding, and we've tried to refer the case out to a legal aid lawyer, it can be really hard to find a lawyer who's going to take a case on, even with a grant of funding. And it can take us months to find somebody. That's not only in London. Obviously, some place out of London, there are very few lawyers that are willing to do legal aid or immigration work. But even in London, it can be really hard. And an example here, we had to try, we got funding for one case in August 22. We had to try over 40 firms before we got someone to take him on. And it wasn't that the case didn't have merit. We got funding. The legal aid agency acknowledged there was merit. It was just they didn't have capacity to take on the case. So that's a real problem. And obviously, moving forward in terms of the Borders Act, the most recent Immigration Act, and the NABA, and then we've got the immigration bill as well coming through, legal immigration bill. We're going to see people needing access to lawyers, but not being able to find lawyers who are going to be able to take them on if there's this is such a shortage. So that's going to be a real problem. So we'll find people to represent themselves even more, with even shorter timescales to do it in as well. But as I say, we do make applications, so we can assist. And we have on our website a self-help guide to making applications for legal aid funding, which some people, some individuals do find useful if they are able to, if there aren't language barriers or education barriers, people can do that themselves. We made it as simple as we can, but really often it's hard for them to set out their case, even unless a lawyer or pro bono body does it for them. Okay, so that's the background. It's a bit about the paperwork that people get. I just want to just flag up the actual steps and the procedures. So basically, there are two stages to the deportation process. Stage one, liability deportation, what's called a one-stop notice. And that's so the Home Office write to the person and say, look, we are considering making a deportation decision. If you tell us why you think we shouldn't make one, and tell us within a specified time. And you've got to respond to that within the time scale given in the letter, and explain why you think you should be able to stay in the UK, and that could be based on your human rights or your protection matters. But it's what I want to flag up in that is it's very important that that person replies to that notice, because if they don't, there's a potential that they won't have raised a human rights claim, which means that they may not get a right of appeal when they get the stage 2 decision, because there's no human rights claim to refuse. Because a stage 2 decision, a decision to deport, is really a refusal of a human rights claim. So it's really important somebody that the people reply to the one-stop notice and put all the reasons down. So stage 1, tell us why we shouldn't. Stage 2 is where the Home Office say, well, thank you for giving your reasons, but we've decided that we've taken into account, we think you still should be deported, and here's our reasons. That's a full deportation decision letter, usually quite long, and it usually comes with the right of appeal. We have got a new priority movement notices, which is going to be introduced under NABA, the most recent act. Those haven't come in yet. They're going to be similar to the one-stop notice in terms of having to set down all your reasons why you shouldn't stay and be deported, but they're going to have much more serious implications, potential for people, if they don't reply to those notices before the specified deadline for doing so. We haven't those on in yet, so I'm not going to go into that, just to flag up that, you know, the pressure on people to identify why they want to stay in the UK and shouldn't be deported, to do it in a timely manner, getting all the reasons down, the pressure is an ever increasing one. We're applying to the one-stop notice. So as I said, this is really important. So I just want to flag up some key areas that people need to be aware of to apply to those notices. And people often, particularly people that we've found that people in prison, often they don't reply to them, because they don't know what they're supposed to do. They don't realise the importance of it, and they think they need a lawyer. I think that's the case often with deportation paperwork. People often think, oh, I can't do anything, I need a lawyer. You don't need a lawyer to respond to these, and it's, you know, if you haven't got a lawyer, it's really important you put your key points down within the timescale, and if you get a lawyer later on, they can make submissions afterwards, that's fantastic, but you really do need to get those applications, those responses in. I say that you're raising human rights claims, that's really important. And often it's just putting down all the reasons you believe that you should stay in the UK, so the basic points. It doesn't have to be legal terminology, just I've got a family life here, relationship with the children, a partner, and providing any evidence you've got. You know, if you haven't got the evidence initially, you don't have to wait for it. Just say, well, this is the evidence I've got at the moment, this is what I'll provide, and this is when I think I should be able to get that evidence. But it's really important that people don't hold off replying to those the one-stop notices within the deadline, because they haven't got all the paperwork. And I flag that up because often we have people in prison who say, oh, I didn't send it in because I didn't have the birth certificate, my partner has it, and I waited for her to send it to me, so I just didn't respond, because the Home Office, I thought they wanted all the paperwork. You know, it's really important you'd actually respond and get the key points in. You've got your application, you've got your response in, you've raised your rights claim, you can add things further, so put in what you can. But another thing is, just to flag up, is that it's helpful to show if you've been in contact, if the person's been in contact with their partner or the children through visits or phone calls, the person can get those records of visits and phone calls from the prison. Just write down, I'd like the records, and that's really important, because just to show the ongoing contact, because people often regular phone contact and visits, but people don't know that they need to evidence that if they've got a lawyer. But if you can evidence that, it's really important to get those documents. And just explaining how you think the children will be affected. And often we found that, you know, we speak to the partner and they say, well, the child, you know, my child's really missing their dad. Is often the dad is in prison. They're behaving badly at school, or they're playing up at home. And so, you know, it's worth making note of that and what's happened and when, if you've been called into the school, if parents been called into school, etc. Make a note of what's happened and when, because all this is important evidence as to the, you know, if the child is having difficulties separated from the parent who's in prison, even though they can maintain contact with phone and visit, it's indication, a helpful one, of how they might respond if that partner, the person is removed to, you know, thousands of miles away, and they can't even have that one-to-one contact, the regular phone calls, particularly not being able to have the visits. So it's just about evidencing as best you can, you know, building evidence up so that when you get to the stage 2 decision, and they do tend to issue a stage 2, it's pretty standard, you've got that evidence there to put in as part of your appeal work as well. Yeah, for elected residents in the UK, again, you can demonstrate that through letters from GPs that you've been registered with a GP for a long time. Even if you've been to school here, the client I mentioned who came at age 2 or 3, we've got all the school records, we've got lessons in schools to show they've been there for. There's quite a lot of evidence you can get. It's a lot of work though, which is why I said it's important to have a lawyer if you can. Particularly hard if you're in prison or in detention centre, because you can't access those records easily, write the letters, make the phone calls, use the internet, particularly in prison. So it'd be quite hard to do that, but just evidencing as best you can. If you've been linked to community groups, again, letters from those, and if you can show the integration in the UK is important. Rehabilitation, that's an important one. Any courses taken, or in the course have been taken, or you've registered for them, that's important as well. Any physical health and mental health issues, again, you can get your mental health records, or sorry, I say mental health because most people who are in prison or detention centres do tend to have some mental health issues, depression, particular anxiety, but you can have also sometimes physical ill health. They can request their records from the prison or the removal centre, and that can be quite useful as well as evidence. Any obstacles to integration, again, just to explain what those are: language, lack of family support, lack of familiarity with the culture. Address those points, because the Home Office will put those in their refusal letters. So the more you can put in as to why you think there'll be difficulties, the more the Home Office have got to engage within decision letter, and if they don't, again, you're at stronger point when you're going to appeal. So it's really worth putting those down. A bit about the appeals process in a nutshell. I mean, you could do a whole course on appeals, but in a nutshell, as the appeals system is presently, and I say because obviously there are upcoming changes but haven't been finalised yet. Basically, most people who get the stage 2 can the deportation decision, full decision letter, and deportation order can apply or can appeal to the first 2 tribunal. Again, you don't need a lawyer to do that. Again, it's a form, it's an appeal form. People often think, oh, I need a lawyer to do it. You don't. You can. The person can fill the form themselves. They just got to put the basics there, put their basic name and where they are, etc., and the key reasons why they disagree with the decision, Home's decision. It doesn't have to be in legal terms. It just can be key points why that decision to deport is wrong. I just want to flag up if people are filling in those forms, it's always worth applying for an oral hearing, not paper. And I say that because oral hearings are more expensive than a paper hearing. I think 140 compared, I think paper is 80. But it's important, it's really helpful to have their day in court and to be before that judge and to be able to give their evidence, their witnesses to give their evidence is really important. We have a leaflet on our website about fees. And fees are payable for most Article 8 cases, but there can be a fee waiver if a person's unable to pay. But there's more on our website on that. I should also say that also on our website we have how to respond to the one-stop guidance on applying to one-stop notice as well, which you might find useful. But again, with the appeals, the deadline to appeals are 14 days. But a person can make a late appeal if they can show good cause the entire period that appeal is late. But obviously the longer they're out of time, the harder it is to get the tribunal to accept good cause for that whole period. But this is really important because we often get people who, particularly again, people in removal centres or in prisons, who have missed the appeal deadline and then think, well, I can't appeal, that's it, I've missed it, that's it. But you can, it's really important, people can put the late appeal in. All they've got to do is fill the box in on there's a box on the form, explain why your appeal is late, put your basics in there. And the courts are, particularly people who are in prison or removal centres, they're fairly realistic. They know the difficulties people have of applying, particularly people in prison. So it's always worth putting it in. But for people in prison, no access to legal advice, then I mean that's a good reason. And people just didn't know they could do it, or didn't understand how to do the form. Language barriers, health issues, problems with reading and writing, all these are valid points. So it's always worth putting the application in. And once you do, the tribunal will then decide whether or not to allow, whether it's good grounds or to allow that appeal to go ahead. But I see the courts are, depending on the circumstance, obviously, but they're fairly reasonable in terms of being aware that the refusing late appeal has massive implications for people in terms of their human rights and their ability to resist deportation. So it's always worth pushing the late appeal in if they can. Again, a bit about, as I said, when people are often having to represent themselves because of lack of access to legal aid lawyers. So I wanted just to flag up, and I know that often people are supported by community organisations. Obviously, people have to be careful as to making sure they don't give immigration advice if they're not registered or qualified to do that. But often people will help people to gather the information, the evidence and arguments that are needed. But just some basic tips on how to, if people do need to represent themselves. The Home Office will prepare what's called a respondents bundle, which is all the evidence that they want to rely on for the court hearing. And it's always worth checking through that bundle in detail, because often we found that people have sent in evidence and arguments often over the years, and it isn't in the bundle. So it's important to check what's in that bundle, and if things are missing, to say, well, actually, you have included these points in this paperwork I gave you, my letter from my partner, my marriage certificate, my birth certificate, and my child's birth certificate copy, etc. They're not in the bundle. So check what's in the bundle. That's really important. And you usually get the bundle before the you get it before the hearing. And often, if there's a case management hearing and like administrative hearing before a date set for full hearing, often the Home Office will give it at that point. But that's really important to check. Again, also, it sounds very basic, but it's very important to read through the Home Office decision and note down the points that were rejected and why. And I say that because often these letters can be really long. They can be 15, 20 pages sometimes, lots of information. People are like panicked and they're confused and worried. They don't often read them properly, but it's really important they read through and make a clear note of anything they disagree with, because that's when it gets to court, that's what we're going to be focusing on. What do they reject about what the officer said about why they should be deported? That's really important. As I said before, in response to the one-stop notice, again with this, obtain any supporting evidence you can, statements and witnesses, family, friends, community organisations that you want to rely on, and to just provide as much supporting evidence as you possibly can, so when it gets to court, the judge has got that before them. And just to flag up, because I say people don't often realise that if someone writes a witness statement, it's helpful if they come to court, because if someone writes a statement and doesn't come to court, often the court will attach little weight to that statement because the person's not there to be asked questions about it, or they can't be kind of cross-examined about that. So it's really important they come to court as well. And we've seen loads of cases where, you know, the judge said, well, this person wrote a statement, didn't come to court. I just, so, you know, it casts doubt on the kind of credibility of that statement. They can't be bothered to come to court, but it isn't often the case not being bothered. The person didn't know to ask them to come to court. So that's really important. Again, another really important point, and this is on our website, on a leaflet representing yourself at appeals, witness statement. It's really important the person writes a witness statement setting down all the key points, what they accept, what they reject, why they reject it, and covering all the key points of their they want to rely on. So a paragraph on time spent in the UK, family life, issues with return, health issues, rehabilitation, obstacles integration, all the kind of things the court's going to look at, put them in the witness statement, so the court's got that before them. And we're running out of time, so I'm going to stop in a second. I may not get to all of the slides, but you'll have them. In a nutshell, if someone's turned down at the first tier, either party can apply for permission to appeal on points of law, not just because you disagree with the decision, but asking on points of law. Generally, someone needs a lawyer at this stage to draft the grounds. And if the application is refused, permission to appeal is refused, it can be renewed direct to the upper tier, but no onward appeal if that's refused. So at that stage, you're going to need a lawyer. But for the first stage, it's best to have one, but it's not, you know, there's things you can do to try to make out your case without a lawyer. Very briefly, revocation. If someone has been in the UK, has got a deportation order against them, hasn't been removed, an application can be made to revoke the deportation order if you can show there's been a change in circumstances as such that now it would breach their human rights if they were to be deported. And certain tests to be met, which I haven't got time to go through, but it's in the slides. Fresh claim test is in the slides also, which I'm going to run through, but it's there, the test to meet. Just very briefly, I won't go into this because we haven't yet got this in force, but we are going to have speeded up appeals and possibly truncated appeals and much more pressure on people to put down why they should be deported in a short space of time, with big implications if they don't do it in time. But I won't go into that now. I'll put another training course when they come in. And of course, we have the Legal Migrants Bill, which is going to going through the Parliament at the moment, which potentially blows a lot of what we've talked about here away in terms of challenging decisions. But again, I think you have a talk on that coming up, so I won't go into that. Right. So future, as I said, things are going to get worse. So people need, without lawyers, if their rights are reduced, time to challenge things reduced, very little access to lawyers, but you're going to need support in terms of probably finding having to do things a lot themselves with the support of voluntary organisations. So I'm going to end there, and I hope it gives time. I know got overrun. Time for questions.
Thank you, Carmen. That was a really, really helpful overview of what people can do when they don't have representation, especially. There are 4 questions in the Q&A. So the first one, someone said, so the Home Office cannot deport a family with children nor an unaccompanied minor until the age of 18. So maybe just some clarification around separated children.
Yeah. So yeah, they can remove a person who's got children, so the person would have to show that the unduly harsh test is met, that they meet the exception to deportation, which I mentioned, have to show be unduly harsh in the child to remain in the UK and to be parented by a single parent, and to actually relocate to the country of origin, to relocate to the person's proposed country of deportation. So yes, they can, and it's for the person, you know, we have to show it's unduly harsh to do that. Yeah, they shouldn't deport somebody who's under 18. I've never come across them trying to deport somebody who's under their age. Or everyone I've ever had has been, they've often committed offences before 18, but they've committed offences 18 and over as well. And when the deportation actually has taken place, they're adults.
Thank you. And the next question is, do letters of support from charities and organisations help as evidence? These letters can usually be drafted for free by local NGOs and groups.
Yeah, I think they do. I mean, basically, if those letters can go to addressing any of those points you've mentioned, they have to show about the integration in the UK, family life, etc. Then yes, that they can be useful. I mean, ultimately, what you really want to be looking for is to get a lawyer to get expert evidence. I mentioned where you really, the best thing is to get expert reports. But if someone can't get a lawyer, can't do that, then I think statements are helpful, as long as they go to the points that have to be addressed, you know, in that particular case. Yeah.
Brilliant, thank you. And there is another question around social and cultural integration, which is volunteering in the community considered as evidence for social and cultural integration?
That's a tricky one. I mean, that can be part of the evidence, but you're going to need more than that. But basically, I mean, we would argue that anyone who's been here a long time is going to be social and culturally integrated. The offending alone doesn't undermine that necessarily. I mean, partly volunteering can assist, but I would say it depends a bit on when they started, because we've often, you know, we've had cases where the judge has said, well, we note that you've only started volunteering after you got a deportation decision, and therefore we don't think it's genuine, therefore we think it's like just always contrived, you know, it's done for a particular motive of trying to support your challenge deportation. So it does depend very much on the circumstances. I wouldn't say it's going to swing it, the fact that somebody is, you know, volunteers, but it can be helpful if you've got that as part of the broader evidence of your time with the UK and integration and the time with that organisation. It can be helpful, definitely, but it's not going to be, certainly not enough on its own.
Yeah, both of those things. It's heartening that people are trying to think of ways that perhaps in their organisations they can help people that they know. It's not going to do any harm, is it? But it's perhaps not going to be enough to cross that line, but maybe as part of that whole bigger picture. And definitely, so I'm a social worker, so it might be if you are commissioning that social work report, it might be useful information to know about as part of that assessment. So it could be helpful for that whole wider picture of what's happening in children's lives.
Yeah, absolutely. Yeah.
And there's a final question, it's 7:30, and the last one is about this overlap between the asylum system and immigration. So they're asking, asylum seekers have not lived lawfully most of their life in the UK. What chance do they have to prove they should not be deported?
So I don't work often with asylum seekers because they get legal aid, they're covered, and I do pro bono work. But I mean, ultimately, obviously they've got the protection matter, so that's one thing about staying in the UK, not being deported. But certainly often if they've been here for a long time, they may not meet the lawfully residence test. And I don't deal with enough with that to actually be very clear. I haven't dealt with that kind of case. But even if they weren't here lawfully, and obviously they're going to have, they're still going to have, interactions or social networks here with people. Often they're in the system a long time, so they will have built up a social and cultural network here and support networks. So that's going to be relevant in terms of resisting deportation. And often they also might have a partner or children, which can be run as part of the arguments. So, you know, even if they don't meet that lawful residence test, you've also got the broader test of social and cultural integration, which doesn't, you might not meet the private life test as set down, lawfully resident in the UK more than half your life, plus social integrated, plus racism obstacles. You may not meet that, taking the facts of your case, but you're still going to have lots of arguments probably about social and cultural integration and the impact on that private life if you were to be deported where you don't have that equivalent kind of support network or family network.
Thank you, that's really helpful. Something, and I'm not a lawyer, so I probably don't understand it properly, and it was quite a long time ago, but I'm remembering is from a case I worked on a long time ago. Is it the case that if someone's got refugee status, that it can be revoked, like the Home Office might apply to revoke the refugee status before a deportation order?
They can apply to revoke that. So what we'll often see is somebody had refugee status and then they commit the offence and the Home Office proceeds the deportation. They can apply, they write and say, we're going to revoke deportation, your refugee status. But there's certain process have to go through, but they can't just say we're revoking it. They have to go through certain steps to explain why they're doing that, and you can put in suspicions to why that shouldn't be done. There's a very particular process how they have to go through, but yes, they can do that. It's not that someone who gets refugee status is protected for deportation. That's it. Yeah, they can take it away. But the court, obviously, then you go to court and the court would look at that matter. So that would be part of your appeal. Your deportation appeal is going to cover that point also. Should it be revoked or not? Yeah.
Brilliant, thank you. I don't think there's any more questions. I think we've answered them all. Just double check the chat in case I've missed anything. No, I don't think so. That was everything. So I will stop it. I'll stop the meeting for everybody. Thank you, Carmen. It was really, really helpful, really useful. We will send slides in a follow-up email to everybody who signed up to come today. And yeah, thank you for everybody who came.
Great, thank you. Thank you for attending. Yeah, it's really excellent series. Thank you.
Bye.